I'm a very ardent believer in that. So the same thing, even when I'm talking this class also, it is God who is taking it through me. Okay, so whatever mistake will be there, it will be mine. But whatever I do well, it is all attributable to God. Okay, so shall I start?
Yeah, please.
Okay, so I've shared the presentation with you all. See, the purpose of this session is there'll probably be a lot of, you must be thinking that I'm splitting and reading the regulation, but I am doing it specifically on purpose because I want this session to be giving you an entire picture about the regulation so that you don't have to look back at the regulations. You look at these, it will give you an idea about what the content is. So you don't have to go back to the, then I will discuss two orders that have been issued to show what are the areas where the regulator is interested in. So I will try to take these two. And as far as cases relating to surveyors and other things, I have a folder. I think Mr. Mithilesh would have talked about the surveyor related thing, or I will share a folder where these Supreme Court cases relating to surveyors are all bunched together. Some of them have been overruled, distinguished, etc. So those I will also share with you, and maybe when we have a binding up class, maybe Amandeep Singh sir and Mithilesh sir will be more appropriate people to be discussing the nuances of those cases. But my mandate as far as today is concerned is to give you the glimpse of this regulation, sir. And let me tell you that at the time this regulation was framed, I was there in IRDA and I was in the legal division there, but this was not something that I have vetted. So when I'm reading it, and subsequently there have been two rounds of amendments which have been brought into these. One, I think around 2017 or so, then another one in 2020 they were brought in. And you will be in a position to see those changes. Some provisions have been dropped regarding the classification of the surveyors in different categories. So those kind of things have been dropped. But by and large, the regulations cover aspects relating to conditions of grant of license, then refusal, suspension, refusal of license for individual surveyors, corporate surveyors, then suspension of license, cancellation of license, rejection of application for license or renewal, then code of conduct, then trainees, what is the role envisaged for ISLA, what is it, Indian Institute of Insurance Surveyors and Loss Assessors, which is supposed to be a professional body for dealing with these. So this first I will try to give the provisions which are relating to surveyors and loss assessors, and those provisions in continuation with which exercising powers under which IRDA has come out with these regulations. So shall I start? Hope you are able to see my presentation.
Yes, sir.
Yes, sir. Yes.
You're able to see it, no?
Yes, sir. Yes, sir.
Yes.
Sir. Yes, sir.
Yes. So I'll start off. So the most important provision relating to surveyors and loss assessors is section 64 UM, which deals exclusively with aspects relating to assessment of damage in life insurance claims by persons who are having the qualifications and who meet the requirements that are specified. So that coverage relating to that is in section 64 UM. I will be dealing with the individual sub-provisions about this as well. But surveyor and loss assessor is named as an intermediary or insurance intermediary under section 2F of the IRDA Act. Then the provisions of Insurance Act dealing with intermediaries are section 42D, which talks about the issue of registration, and 42E, which talks about conditions that can be stipulated for an intermediary or an insurance intermediary by IRDA. So the first section, that is section 64 UM, says that no person can act as a surveyor or loss assessor in general insurance business 1 year after the Insurance Amendment Act came into force, unless he possesses academic qualifications as specified by IRDA. So the academic qualifications have also been revised, and they are forming a part of Schedule 1 of the IRDA's Surveyors and Loss Assessors regulations. Then second, he is a member of ISLA, which is a professional body for surveyors and loss assessors. I I have what is it? I know that there are certain issues relating to ISLA, but I would like the surveyors and loss assessors to come out with their points relating to this. So because they may have a different picture than what IRDA has about ISLA. So if you are having any information about ISLA, I would like to hear about that. Because I tried getting some information, but then the person in that department was indicating that you ask me the right question, I will give you answer. But you throw me what is it, a broad net, and I am not going to fall for it. So I will not. I will not try to broach those issues, but I will only indicate that there are certain issues with ISLA as a professional body, and the regulator and this professional body don't seem to be in the same page. And that friction between them is something which is affecting the smooth conduct of the licensing and registration aspects of surveyors and loss assessors. That much I can definitely say. Then in case of a firm and company, so this is in case of individuals that they should possess these, but in case a firm or a company also can engage in surveyor and loss assessor business. So in that case, all those partners and directors who are called upon to do that survey should fulfill the academic qualifications and membership requirement. Then every surveyor and loss assessor shall comply with the code of conduct in respect of duties, responsibilities and professional requirements as specified by IRDA. So the regulations, there is one regulation which I think 13 or something like that, which talks about the code of conduct. There are 21 items and 3 more sub items have been added. I have not made it a part of the presentation because it will be what is it? Some of them appear in the duties and responsibilities. Some of them are very obvious. So if I have to run through, I will just run through those in the Word document, which is there in the consolidated regulation. Then existing licensed surveyors and loss assessors will be allowed to continue to act as surveyors and loss assessors for such period as specified by regulations, provided they satisfy the requirements of qualifications and membership within that period that IRDA will specify by regulations. So this also we will touch about. There is an indication saying that if you have already become a student member, you will be given a period of 1 year to comply with the requirements, or 5 years, whichever is later. So that kind of a provision is there, which is probably giving a rope of 5 years for the entities to satisfy the requirements which are specified by IRDA. Then no claim or loss in India required to be paid or settled in India equal to or exceeding the amount specified by regulations on an insurance policy can be admitted for payment or settled by insurer unless he obtains a report from a person who holds a license as surveyor and loss assessor. So this is an important clause where there has been a modification. Earlier a fixed amount of 20,000 was incorporated here. Now what they have done is they have given operational flexibility by taking this out and assigning it to IRDA to specify the amount through regulation, and that is what they have done. And there was a thinking that this amount has to be further increased, but they have stopped at the 50,000 and 1 lakh limit only, which again is one of the regulations that is there in the surveyors regulation. Then however, they are making it very clear that the right of insurer to settle any claim at an amount different than as assessed by the surveyor and loss assessor is not taken away or abridged. So there is a decision of Supreme Court which is recent, which says that just because you are given this right to settle the claim amount at any amount different than what is assessed by a surveyor and loss assessor, you cannot exercise that power arbitrarily. You need to have proper logic and reasoning for taking a decision which is different from the amount that has been assessed by SLA, so by surveyor and loss assessor. So this is another important aspect. Then IRDA may call for an independent report from any other surveyor and loss assessor. So if someone says that I am not satisfied with this, they can approach IRDA, and IRDA, if it is satisfied that that has not been properly done, then they can assign the responsibility to another surveyor and loss assessor to give them an independent report. And then this surveyor and loss assessor should report to IRDA within specified time or within reasonable time. Then the cost of costs which are incidental to furnishing this report by that IRDA appointed surveyor is supposed to be borne by the insurer, because ultimately it is his responsibility to satisfy himself about the loss assessment and then make the claim. Then IRDA, what it will do on receiving its report. So after scrutinizing the report, IRDA may issue directions with respect to settlement of the claim, including a direction to settle the claim at an amount less than or more than that at which it was already settled or it was proposed to be settled. So it is not necessary that even the pre-settlement and settlement stage only it has to be done. Even after it is settled, then it can be done. Even after it is paid, they can still approach IRDA and then request for an independent auditor. That is what is the sense that you get out of the reading of these provisions. And it is very clear. It is coming out even more clearly in the subsequent provision, which says that if you have already paid and if the IRDA decides that this particular thing is supposed to be paid at an amount less, you should satisfy that you should be in a position to recover. And if the recovery makes it very difficult for him, then IRDA should not give that kind of a direction is what is there. So the sense of this provision says that approaching IRDA for an independent survey can happen at the time that it has been settled, at the time the proposal for settlement is received, or at the time that it has been settled and the amount has been paid as well. And wherever any such direction is issued by IRDA on the basis of this independent report, the insurer is bound to comply with such directions. The option that is there is bound to comply according to this, but if IRDA itself is not doing well, then there is nothing which is stopping them from filing a writ petition before the court, because IRDA is state according to the provisions of Article 12 of the Constitution of India. Okay. Then if IRDA directs for settlement at a lower amount than was settled, then insurer is deemed to comply if he satisfies IRDA that all reasonable steps have been taken, considering the question of expenditure involved being not disproportionate to the amount to be recovered. Say if he says that 100 rupees is supposed to be recovered, and for recovering that 100 rupees, I will have to give a notice which is to be sent by registered post, etc. If it is going to charge me 2000, if he says that you have asked for 100 rupees to be recovered, I am okay with it, then that should be sufficient as far as the compliance is concerned. Then second thing, IRDA will not issue a direction for settlement of a lower amount if it feels that recovery of excess amount could cause a undue hardship to the. Here they have left it like that, but basically if it causes hardship to the insured, then it will not be appropriate. Then this provision is very important, which says the civil and criminal liability to which the insurer is subject to will not be relieved by compliance with the order. So if after compliance with this order also, if someone wants to take up any claim against the insurer and hold him liable for civil or criminal liability, he will still be subject to that liability. That is what this subsection says. Then after 26/12/2015, why am I saying 26/12/2015? In the first provision also it is said that the Insurance Laws Amendment Act came into being in 2015. But the Insurance Laws Amendment Act was brought about initially as an ordinance, and that ordinance became effective from 26 December 2014. And when the Act came into being, the date of effect of it continued to be 26/12/2014. And 1 year after 26/2014, wherever you are referring, means 1 year after the 26/12/2014, it becomes 26/12/2015. So no insurer shall pay fee or remuneration for surveying, verifying and reporting about claim unless the person is an approved surveyor and loss assessor. So you should have qualifications, you should be eligible, you should be member, then you should be qualified surveyor. Then only if you are qualified surveyor, you will be eligible for getting the remuneration. Then for claim amount less than specified by IRDA. So ideally speaking, where the claim amount says 50,000 and below 50,000 in case of a motor or below 1 lakh in case of other insurers, if according to this, IRDA does not require a surveyor and loss assessor to be appointed. So here where employing a surveyor and loss assessor, if it is not practicable, then they don't have to. And in that case, the insurer may employ any person for surveying loss and may pay reasonable remuneration. And here they say that it should not be a disqualified person. That is, they can't bring a madcap and say that you now survey this because it is within 50,000 or 1 lakh. So there has to be some sense in the kind of persons that they are employing also. For survey, though it is not required that an approved surveyor and loss assessor only should assess these claims. But if IRDA makes a direction to appoint a surveyor loss assessor for such a claim, then the insurer has to do so. And once IRDA says in a particular claim that you have to appoint a surveyor and loss assessor, all those provisions that are there relating to submission of report, bearing the cost, then IRDA's direction to be given after examining the report, all those things will kick in where IRDA gives the direction, notwithstanding the fact that the claim amount is less than that which is specified by regulations by IRDA. Then IRDA may by order exempt claims from the purview of this section if it is customary to entrust work of survey to persons other than licensed surveyor and loss assessor, or it is not practicable to make any survey and loss assessment. In these cases, there could be an exemption from these issues, like maybe if there is a huge fire or if there is something where you fear people to go there and have a survey to be done, then in those cases IRDA may exempt the application of these provisions. Then the other section which is important in case of registration as far as intermediaries are concerned, and because surveyors and loss assessors are intermediaries, the provision relating to registration is important. So the registration is valid for 3 years from the date of issue. Then application for renewal has to reach IRDA within 30 days of expiry of registration. Then they have to make a payment of fee, and according to the regulation, the fee is 1,000 rupees for individual surveyor and 5,000 rupees for a corporate surveyor. Then if the application is not reached 30 days before expiry, there has to be an additional fee which is not more than 100 rupees as penalty. But if the application comes after 30 days after the expiry, then it's not mandate. It's not necessary that IRDA should accept this. However, if IRDA feels that there is going to be undue hardship in not allowing this renewal application to be accepted, then they can impose a penalty of 750 and accept the application for renewal. The other important aspect for which always this section is referred to is in terms of the disqualifications of persons who can be intermediaries or insurance intermediaries. The first thing is minor, no capacity to contract. Then unsound mind, again no capacity to contract. Then third, moral issues of having such a person to be doing surveying and loss assessing if he is guilty of criminal misappropriation or criminal breach of trust or cheating or forgery, or if he is guilty of abetment of or attempt to commit any offense, any of the offenses. So here guilty of means not filing an application, not filing an FIR. You are deemed to be guilty only when it's not necessary that you should be convicted of, as the word says. So maybe even a charge sheet would be sufficient, or maybe if you are convicted, then this automatically disqualifies you. Then once you are found guilty of this, it means that you have been convicted. So 5 years after completion of your sentence, after that only you will be eligible to take up the come back for getting a registration as a intermediary. Then in the course of any judicial proceeding in respect to the policy, or in winding up of the insurance company, or in investigation of affairs of the insurer, if the person is found to be guilty of knowingly participating in or conniving at fraud, dishonestly, or misrepresenting against the insurer. So basically, wherever there is a need for him to give information or not make proper representations, in those cases he makes wrong representations fraudulently or dishonestly against the which go against the insurer or an insured. In those cases also he is not someone who is trustworthy, so he can't be assigned the role of being an intermediary. Then not having the requisite qualifications and practical training as specified in the regulation. So this acts as a disqualification here, and there you don't get an eligibility under 64 also. Then not pass the specified examinations, then violating the code of conduct specified. So in all these cases, the consequence would be that you could have a penalty that could be imposed. Then you could have the certificate of registration cancelled if you have knowingly contravened any of the provisions of the Act. Then if the registration certificate is lost, then or destroyed or mutilated, then you can get a duplicate registration at a fee. Then doing business of an intermediary without registration will make you liable for a penalty up to 10 lakhs. And if it is a company which is doing this, then every director, secretary, manager, officer will be liable unless he proves that he has either not a participant in it, or he is not party to the violation. Then he will be exempt. Otherwise, all these people are deemed to be persons who are liable. Then person who appoints such an intermediary will be liable for a penalty of 1 crore. So an insurer who engages a surveyor who is not licensed, then he will be charged 1 crore penalty. Then 42E talks about the conditions for an intermediary or an insurance intermediary. So here, authority may by regulation specify the requirements of capital, form of business, and other conditions to act as an intermediary or an insurance intermediary. So exercising the powers under these, IRDA has come out with the Insurance Surveyors and Loss Assessors Regulations 2015. And these regulations were made after the consultation with the Insurance Advisory Committee, which is set up under Section 25 of the IRDA Act, which is a body which again has 25 members coming from ex officio as well as other members who are coming from various disciplines which have a bearing on insurance, which have a bearing on consumer protection, and also from the insurance sector. Then these notifications were effective from 3/11. Then the powers to issue these have been derived from Section 14. Section 14 is talking about duties, powers, and functions of authority. So under that, matters relating to claim handling, etc., it requires IRDA to come out with ensure that these functions are performed well. Then power to make regulations is there under Section 26. So whenever there is any regulation, you will have these sections cropping up. Section 14 read with Section 26. Then because the provisions have to be made under Section 42D, 42E, as well as 64 the power to make regulations under these are provided for under Section 114A of the Insurance Act. Then Section 42D also gives power for stipulating conditions, for giving disqualifications, etc. Then 42E giving the conditions for insurance intermediary. Then Section 64 So exercising all these powers, you have the regulations that have been made. So I will now just take a breather, and if there are any questions, I think there is one area where there has to be clarity is that guilty of means you should be convicted. It is not that you will only have a charge sheet and then you will be treated guilty. So it has to be a proper conviction where you are supposed to be held, that you are the offense of criminal misappropriation, breach of trust, etc. are proved against you. Okay. Yes, sir. Sudhakaran, sir.
Yes, sir. That you have pointed out that a surveyor can be appointed by an IRDA if a complaint is received by the insured. Is it by way of grievance, or it is a normal complaint only?
It has to be, see, ideally speaking, it has to be by an application which indicates that I want you to exercise powers under Section 64 3, 4 or something, 5 and 6, I suppose. So
it can be taken up. It can be taken up with the insurer itself, no, sir? Because
yes. See, one thing. Why do you approach IRDA? First,
insurer is not taken.
In the internal grievance redressal system, see, most of the insurers, as I understand, have first a claim group. Yeah. Then subsequently they will have a review.
Yes, appellate.
Okay, claim review committee ke paas bhi you go, and then you turn. They are not satisfied with you, and you have a grievance in relation to the survey that has been done. Only they want to have. See, maybe the survey is properly done, but I am not satisfied with the amount that they are claiming. So then I don't need to exercise the powers under Section 64 But where I have problem with the survey per se, but I want someone else to do that function as an independent authority, then I will have to approach. And ideally speaking, if some policyholder wants to apply, they have to specifically indicating that I want to invoke this under section 64 UM. So that has to be grievance it will go into the general pool, and IRDA will automatically give saying that IRDA does not only facilitate grievances, but does not. That is the position.
Okay, one more point, sir. That if the amount is lesser as prescribed by IRDA for like motor, it is 50,000. Is it insurer can appoint any person or only existing employee in-house surveyor?
Any person. The provision is
any
very
person.
Can appoint any person provided he is not disqualified. The only thing that is there that he should not be disqualified. Otherwise, disqualified means any of those kinds of categories that are there. No, so wo chhod ke he can appoint anyone.
Okay, insurer is appointing ex-employee or retired employee. Is it okay? No.
And that should be fine. No, there shouldn't be a problem to that.
Correct. Okay, sir. Okay. So that is my query.
Yes, sir.
Thank you.
Anyone else? Anything else?
Sir, one point from my side, Venkatachalam here.
Yes, sir.
Sir, so in case if IRDA directs for a settlement at a lower amount than that was settled, or suppose the insurer has not settled any amount, and the IRDA, because of the dispute with the surveyor, between the surveyor and the insurance company, appoints an independent surveyor. The independent surveyor assesses an amount much less than the amount that was actually assessed by the first surveyor. Okay. In this case, the insurance company will definitely be in favor of paying a lesser amount as directed by IRDA surveyor. Definitely give rise to a litigation, or the insured will be at liberty to go to any court of law saying another surveyor has assessed it at a higher level, higher amount, and the survey appointed by IRDA has assessed at a lesser amount. Yes. So the opinion of two surveyors may differ here, may appear to be differing, the assessment. So it could give rise to some litigations. It is possible. See, in that particular case, either way there could be some litigation which could be happening. But here you are entrusting the responsibility to a regulator who is presumed to be having a higher level of knowledge, higher level of understanding, and more importantly, who gives reasonable finality based on the considerations which are there. So he is not the insurer, he is the regulator of the sector. He is entrusted with the responsibility of ensuring that the operations there happen well. So if that person is sitting and deciding that, and he will not give a alto thing, it will be a reasoned order indicating why he wants to give that. And if IRDA comes with that kind of a reasoning and say that where it has to be, where the first surveyor said it has to be 40 lakhs, now I say that it should be only 20 lakhs. So I give my reasons to it. So automatically, if it has to go to a third, this becomes a dispute, and again it will be the court will be the arbiter as far as this giving finality to this dispute is concerned. It's very much possible. And if the fellow doesn't, 9 out of 10 times he will not accept. In which case automatically there will be a litigation. Yes. Okay, so IRDA's intervention is intended to bring in an independent person. So otherwise the surveyors, though their code of conduct and other things warrant that they are supposed to be independent professional functionaries, I am on the rolls of an institution. So whether I will go by the institution which keeps me on the rolls, or whether I go by the responsibility that is there. So to give more objectivity to it, IRDA is given the power to appoint an independent arbitrator, independent surveyor. So if after that you find that there is a discrepancy and it is in favor of the insurer, automatically it will result in a litigation. So it will go. But you will have these documents which will show what is the mind that is applied, first in respect of the first surveyor, second in respect to the second, and 9 out of 10 times. I don't know whether there has been such a case, but there have been instances where IRDA has been asked to appoint a surveyor. So for quite some time they were thinking that every claim will come to me.
but there are certain claims where the court said that you have been given the responsibility and you should follow that. So that is the position, and that also I'll probably get to have some information from IRDA about it, and probably have a a greater look into the mine data in IRDA website to find out what that particular matter is. Okay.
Okay, sir. Okay. Thank you, sir. Thank you.
Mr. Govinder Kapoor, you had something to say or ask, and then you आपने middle drop कर दिया.
I dropped my point because I was not sure if that is a point which you would like to discuss. One of the things in the IRDA regulations is that the insured can also appoint a surveyor. Now, under what circumstances is that allowed? And you see, normally what happens if an insured wants to appoint a surveyor who is different from the one appointed by the insurer, there are cultural issues. So why is the regulation there, or can you clarify that point?
See, the point is that you have a problem now, okay, in terms of having a damage, then you want an assessment of it to be done now. So if you are going to have to wait for 72 hours for someone to be notified and they have to come and they have to do, instead of that, if I know someone who is there, who is a professional surveyor and loss assessor, if I am going to take his services, there's nothing which is going to be wrong, because it's a professional who is a member of a professional body and a person who has been given a license to operate as such by the regulator. So whether it is coming from the insurer or whether it should not make any difference. That
is very well put by you, and in a professional manner. But what is the reality is that when an insurer sees that the insured has exercised his right, it is more troublesome than otherwise, both for the surveyor as well as for the insured.
I will only deal with it. I have not worked on this side of the issue, but I understand that it's a very real problem. How I would deal with it if I would have been in an insurance company, maybe it's a very normative kind of a position that I may be taking. The section says that there could be a surveyor could be appointed by an insurer or an insured. That is there. The person whom I am appointing, either on the who is on the rolls or who is here, has to be someone who is qualified, licensed, etc. That requirement is being met. The section also clearly says that this report which has been given by the surveyor does not bind me in terms of settlement of a particular claim. So considering all this, if the report is incomplete, the insurer has a power to indicate that on these counts it is incomplete. Now you go and give me information. So if he gives information that is required, then I will go by that, and by the information that I am going to ask, I am going to ensure that the job will be done irrespective of whether it is my nominated person or मेरा आदमी या आपका आदमी. But आदमी से काम अगर मैं निकलवा सकता हूं तो निकलवा सकता हूं. That is one part. The second part of it is after he gives the report also, the Supreme Court judgment, I don't go blindly by what you say. I am going to take an assessment of it. Then wherever I am not agreeing with you, wherever I have a different viewpoint, I am going to come out and give my reason. So most of the times what happens in insurance grievances, banking grievances, etc., is people are shy of giving reasons. And most of the problems land up in litigation only because people don't know the reason. Aap reason batao or kaam karo, so none of the liabilities will attract. You will always, even if you go up to Supreme Court, your stance will stay because you have given a reason, and that is what is expected of anyone. You may say that this is not the judicial function that an insurer is performing, but technically speaking, it's as much a judicial function as anything else, because I have the documents before me, I have the laws, I have the terms and conditions of the policy, I have an independent person giving me an opinion about what he thinks about the event, then the loss, the extent of loss, etc. And on that basis, I am taking a reasoned judgment about whether to pay, when to pay, how much to pay. I am my conscience is clear. So even if it goes to God, I will be in a position to stand my word because it is done. But one thing, are the surveyors doing that kind of a job? Are the insurers doing that kind of a job? And that is where you always find that you are about 2 steps behind or 20 steps behind where you have to be. And that is where the problem comes. Otherwise, theoretically speaking, it should not make any difference. As I told you, it's a normative position. Let me give you my own example while I was there in the Ombudsman office. Any case, I used to tell them, I was in the Banking Ombudsman office, Delhi, which was highest number of complaints at one point of time. And the kind of customers they come also are always talking about Ministry of Finance, yahan se aaya, wahan se aaya. So you tell me the person from whom he is coming only, not what his problem is. And the third thing they will say is because Arvind Kejriwal was not the chief minister at that point of time, they used to say, "Ke, मैं RTA में पूछूंगा, RTA में पूछूंगा." So what we did is, everything that is there will have a reason. Everything will have an order, and then your entire file is available for you to take copy of. So when I told, one lady came and she said that I will file an RTA. Then I said, you sit for 2 moments. My peon will come. He will take an entire copy of this file. If you want, I will put it in a file and give it to you. You will have the reason for it. You will have everything which satisfies you. Now you go back satisfied saying that this is written. I don't say that you will have to abide. What is it? You will have to be bound by it. But as far as I am concerned, I have done my best in terms of examining your complaint and giving a reason about why I feel that this has to be resolved in this particular way or not touched by me. Every case that we are handling, if we are going to do this way, then life will be wonderful. But do we do that way? That's the question. Hope I am clear.
Yes, sir.
Govinder sir, if you don't mind, in marine insurance, generally that freedom is there, I believe.
Yes, yes. Marine insurance, no problem. I'm talking about the other surveys where the insurer doesn't like an insured appointing his own surveyor.
So the problem is that the attitude. Actually, this provision when it came for the insured also to like appoint a surveyor, it was, I don't remember the time, but it must have been somewhere in the early 20s, 94, 95. They said, no, not that. I mean, it must have come somewhere in 2001, I believe, or 2002, like that. That was the time when I talked to my colleagues. I said that this is going to create problems. But marine, without stating any such thing, marine, I mean, the surveyors were appointed by the insured and they used to, I mean, we used to get the survey report with all the other documents to settle a marine claim. A similar thing, of course, marine is a different thing because there it's an agreed value kind of thing. And in other insurances, in motor and fire and all that, you have to have a look at the market value and all that, then arrive at a loss. So that thing is definitely there, but it's a question of attitude. And what Mr. Mallikarjun is saying is very clear, that we insurer have to develop that attitude that if the right has been given to the insured, and if he appoints a surveyor, and a surveyor is a licensed person, is an independent person, so we'll have to, I mean, go by that survey report. Unless and until we find something which is missing, we can always ask that surveyor to have a look at it. But of course, it's a question of attitude, so depending on who is dealing at the insurer level. But this freedom was there earlier also. Only thing is it was codified subsequently.
Thank you, sir.
Thank you.
Mr. Ganeshan?
Yes, sir. I want to talk to you, sir. Yeah, normally there are 3 types of surveyors, sir. You know very well. Still, suppose the insurer deputes one surveyor, professional surveyor, another IRDA deputes another professional surveyor who are the specialist, but the IRDA surveyor who is assessing the amount who is assessing very lesser amount, whereas the insurer deputed the surveyor who has assessed the higher amount. What would be the final amount to be decided, sir, by the insurer?
See, one thing, because it has gone to IRDA, again here, it is a point where the insurer has to show some sagacity in terms of handling a particular issue. So he will say, I have assessed it at 1 lakh, तुम्हें तकलीफ था, तुम गए IRD के पास and IRD अभी बोल रहा है कि मैं तुम्हें you are going to get 80,000 only. I told that நீங்கள் இருக்கிறதுனால I will talk in English. I got an assessment. The insurer should tell the complainant that I got the assessment done and I said that you should get 1 lakh. You were not happy. You went to IRDA and he now says that you only have to pay. We paid 80,000. So now I give you an offer. I will give you 1 lakh. You take this amount and let us settle this dispute here. And if he has any grievance, 1,05,000, I give it and I finish off with it. Otherwise, he will have to engage Harish Salve and Mukul Rohatgi has to come and he has to discuss. And for the 20,000, you are paying 25 lakhs to them for nothing. So the cost of litigation is something if it can be assessed. And this is where I think public sector undertakings, the problem that we were discussing is the moment you say that you are showing sagacity, the CVC will come. So you don't want to show even the simple courtesy to put these complaints away. But you are sticking to one stand and say that if I am going to deviate, then there will be someone who will be coming behind me. So I don't want to do that. And ultimately by this, what are you doing? You are creating business for courts, advocates, etc. And the customer is also not happy. He is also not going to benefit because he also has to engage an advocate to get this process and it will take years. What is it? A bird in hand is better than 2 in the bush. Today you get 10,000 rupees less. Is much better than fighting for 5 years. And that is the reason why the provision also says that if the recovery and the reasonable cost that has to be incurred in getting that money back, that is more than the money that I am going to get back, why do you have to do that? That is the meaning of that provision, which says that where IRDA says lesser amount is there, if they take the reasonable steps to ensure that considering the amount to be recovered, etc., that wording, whatever is there, it ultimately means this, that lesser amount if you have to recover, instead of that you forego that amount and say that yes, they have also indicated, so there is nothing wrong on my part. So I said this, I still maintain that I will give you 1 lakh. Let us finish off with it. Let us close this dispute. This can be the approach if it is adopted. Then IRDA's report is also an indicative report, no? Or you still you maintain, then you go and meet in the court and keep spending years and lakhs paying to those advocates, unless you are yourself an advocate and you are creating business for yourself. That is the issue.
Yes,
okay, sir.
Okay, sir. Then another question is, even the Indian specialist or foreign specialist also has to be paid the amount, sir. Foreign specialist. No, this is a professional body. Foreign surveyors are there. They are also invited to register with the IRDA, sir.
Actually, I think intermediaries, when they have indicated intermediaries, 100% foreign direct investment is possible. So I don't think so. You could have
surveyors and loss assessors. Yes. Because marine lawyers agents are there for assessing the amount with regard to marine claims. Similarly, all claims, engineering claims. Engineering claims are normally specialists are required. So normally the world level they will be have to register the IRDA, then do the professional business, sir, surveys business.
Ideally speaking, they will be operating through. I personally, because the regulation here talks about assessment of damage in India, policy in India, etc. So the first clause of 64 UM itself is very clear, saying that this is insert. But if the survey or the matter is supposed to be handled elsewhere, then you need international expertise, you need to take it. And if there is an international surveyor or loss assessor who is supposed to set his office here, they can do so. Because the Act says that it is 100% FDA is permitted. There is no nationality requirement in any of our provisions relating to surveyors and loss assessors. So you could have an international, it is not like in advocates that you can't have foreign law offices opening here. This particular activity of insurance intermediation, it's I think a permitted activity for 100% FDA.
May I interrupt here, sir? Govinder Kapoor.
If I am wrong, please correct me.
No, you are absolutely right. I just want to clarify to Mr. Ganesan that the foreign surveyors are allowed to operate here as if they have a branch or if they have 100% FDI in India. Otherwise, they are not supposed to be appointed by the insurance companies in India.
Yes.
They must have the office in our country. They must have the office in India.
Yes, sir.
Registered office.
Yes, sir.
Branch office or something. No? If it is registered, they could be elsewhere and they could be operating here. Yes.
Yes, sir. Okay, thank you, sir. Thank you.
Thank you. Thank you. Mr. Gaurav?
Sir, I have a doubt. Sir, you said that means both insured and insurer has the power to appoint a surveyor.
Yes,
So my doubt is that can both appoint the surveyors or either of the party has to appoint the surveyor?
Ideally speaking, it has to be only one surveyor. Whoever acts first, his surveyor will be initiating the process.
Okay. Okay, sir.
It is not, what is it? It's not a normal thing that you could have. And I think in relation to this also, there is a, there is a Supreme Court judgment which says that the provision is in respect of only one surveyor. And the one surveyor is supposed to give an additional report if his survey is not appropriate. And if otherwise you want to have a different surveyor. See, man, I personally feel that the provision is not indicating that IRDA should be appointing a surveyor only if the insured approach. There could be an instance where an insured has given the survey report and IRDA, maybe an insurer also, if he approaches, there is nothing in the provisions of section 64 UM relating to who should seek the intervention of IRDA in terms of appointing an independent surveyor. But it is too far-fetched to think that an insurer will approach IRDA to ask for an independent because company is supposed to operate with the individual and get whatever it is supposed to get and then make its decision, because that report is not binding on him, whoever be the person who is appointed. So one surveyor is all that you should need. Okay.
Okay, sir. Okay, sir. Right.
Thank you. Shall I go ahead?
Please.
Thank you. Yes. So you are able to see the presentation now?
Yes, sir. Yes, sir. Yes, yes.
So I will not go by the scheme. The coverage, I have tried to indicate what these provisions are. So basically, one, there is a preliminary, again, short title commencement definitions. Then licensing procedure is an important chapter. There is one for application for individual surveyors for corporate license. Then section 5, regulation 5 talks about fee structure. Then what is the procedure for grant of renewal of license? Those provisions are in regulation 6. Then what should be done when on what grounds a license can be rejected? Application for grant of license can be rejected. On what grounds or what is the procedure for rejection of refusal of renewal of license? Then what is the provision relating to issue of duplicate license? These are all chapter 2. Then an advisory body called Surveyors and Loss Assessors Committee is supposed to be constituted, the functions of it and the appointment of surveyors and loss assessors. So though that doesn't fit into this, section 12 is basically talking about appointment of loss assessors and surveyors and loss assessors, which talks about this 50,000 rupees and 1 lakh. That is that provision. Then duties and responsibilities of surveyor and loss assessor is section 13. Then chapter 5, the categorization of surveyors and the title, those have been taken away. Now you have in this particular chapter, the functions of the institute. Then chapter 6 talks about the code of conduct. Chapter 7 talks about trainee applicants, that is student member, enrollment with IRDA, etc. Then fulfillment of training, qualification, etc., which was there in the regulation 18 here, that has been dropped and it has been incorporated in the initial provisions only, where we are talking about chapter 2, the chapter 2 of the regulations, depending upon the section 3 or 4. Then chapter 8 talks about miscellaneous provisions, that is maintenance of a register of licensed insurance and surveyors and loss assessors by ISLA. Then submission of returns by the surveyors and loss assessors, then submission of reports by insurers. So these are basically mechanisms of having a database and information system relating to surveyors. Then chapter 8 also has provisions relating to inspection, then events and the fallout of suspension of license, cancellation of license, then what is the procedure and what will be the impact of it. Then there is a provision for voluntary surrender of license also. Then a power to chairman to clarify or give some, in case of any ambiguity, etc., they have power to give clarifications. Then qualification requirement for licensed surveyors and loss assessors is section 27. Then 28 is power to frame guidelines. So these are the various provisions. As far as the schedules are concerned, Annexure 1, Schedule 1 is talking about the qualification criteria for enrollment and licensing of surveyors. So what is the qualification for fire, agriculture, loss of profit, etc. So by individual disciplines, then III certifications, etc. So all of them are eligibilities that are there, and specific discipline related qualifications. Then Schedule 2 talks about the formats of various aspects. One is license for individual, then license for corporate, then renewal of license, what is the letter that is given. Then for corporates, what is the letter given. Then duplicate license, how you wish, what is the format. Then records for 3 years, then annual submission of return to authority. So these are the various formats that are there. So this is broadly what these regulations cover. Then the first, as usual, is title, and it is effective from 3/11/2015. And these are applicable to all licensed surveyors and loss assessors. Here the regulation 2 has definitions which are important as far as those terms which are used here and what do they mean. So first, approved institution is basically an institution engaged in education and training in insurance, approved and specified by IRDAI. So basically the institution is Insurance Institute of India, and IRDAI, if it feels like, it can change that institution also. But as of now, the examinations, etc., are conducted by III. Then corporate surveyor is basically a company or limited liability partnership licensed to act as surveyor and loss assessor. But if there are existing partnership firms under the Partnership Act, they can also continue to be corporate surveyors and loss assessors. And who is a designated person? A person designated by IRDAI to discharge functions assigned to him. This will be there where we are talking about conducting an inquiry against a surveyor and loss assessor. So in that particular case, what IRDAI does is they will designate a person to receive a representation and examine the matter. And this designated person will give a report based on which IRDAI will take action against the particular surveyor or loss assessor. Where you are suspending the license of a surveyor or loss assessor, for dealing with the representations, this designated person will come into play. Anything, any? Shall I go ahead?
Go ahead.
Yes, sir.
Okay. Then examination. Passing of relevant examination of surveyor and loss assessor by III or institute recognized by IRDAI. So basically, the way in which this particular provision is defined is very peculiar. Same is the case as far as when you say examination, does it mean to say passing of relevant surveyor and loss assessor examination or successful completion of practical training? So basically, these are taking these aspects is what should be the examination. Then institute means ISLA, which is promoted by IRDAI. So basically it is a Frankenstein that has been created by IRDAI only, and now it is something which IRDAI is finding very difficult to deal with.
Can't say but ये होना है.
Some then surveyor and loss assessor is someone who is licensed by IRDAI to act so. Then student member means the member who enrolls with IRDAI and who is interested in passing the examination and becoming a surveyor and loss assessor. Ranil Sharma is waiting. Okay. Regulation 3 talks about licensing. So basically a student member intending to act as a surveyor and loss assessor in general insurance business should apply to IRDA. And what are the eligibility criteria? The qualifications that are specified in Schedule 1, then any other qualifications as may be prescribed by IRDA, and should be a member of the institute. And this is the requirement which is copied from section 64 UM1. The second part is the examination, that they should pass relevant exams, papers of Surveyor and Loss Assessors exam by III or IRDA recognized institution. And those who have already passed the examination, they are exempted. Then fresh enrollment for student who does not pass the exam and training within 3 years. So he will have to take fresh enrollment. Once this provision came into being, so they will have to seek fresh enrollment. So eligibility criteria, 3 years time for those enrolled within 5 years of notification, but have not passed. So basically there is a 3-year time after you enrolled, and you will within 5 years of the notification, but who have not passed exam and training. So we saw the provision saying that this requirement existing persons can continue provided within the time period specified by IRDA, they will be in a position to comply with it. That provision is something which has been brought about here, and practical training as specified by IRDA. So what should be the documents that are submitted? One is 1 minute. This is some security that's there in my what is it, the place where I stay. So any courier boy or anyone who is intending to come to my society, I will have to give an accept to him so that he will be permitted to come inside the building. So it's this iSociety Manager app in which you will have to do that. Okay. So what are the documents? Basically the application form, then KYC documents of identity of the person and his address and PAN, then qualification and mark sheet to show whether he is eligible, then declaration cum undertaking, then fit and proper statement, then a membership certificate from ISLA, and any other document or information required by IRDA. In fact, a membership certificate from ISLA also, there is a code which has been given saying that if ISLA does not give a membership, then they can write to IRDA, and accordingly, without this membership certificate also, IRDA will permit him to be eligible. So this is something which has been permitted basically because ISLA's the biggest problem is that they don't give membership certificates sometimes for reasons best known to them, or maybe to you people. Okay. The next aspect is declaration, disclosures. So declaration that he will be filing changes with IRDA within 15 days and apply for modified license surrendering the original license. So where there are any changes relating to his what is it, address and other particulars, then he will have to first inform IRDA, and then these particulars, if they form a part of the license, the modified license is given. Then furnish as information as required by the authority, and they will have to enclose the pay the processing fee and enclose the receipt as a proof thereof. Then those applications which are confirming with the requirements, it will be accepted and it will be given, they will be given license. They are liable to be rejected if they are not confirming with these requirements, and they will be given reasonable time for completion of the documentation or rectification. And this is where there is correspondence flowing between IRDA.
Good evening. How are you?
And
I hope I'm not disturbing you.
Yes. Wahab sir.
Actually, I had talked to this guy Navneet actually. प्रशांत सबसे बात नहीं हो पाई तो उन्होंने लवनीत से कहा हो, तो ही कॉल मी. तो एक्चुअली वो उसमें थोड़ा सा वो एनओसी में था, उन्होंने एक्चुअली एनओसी जो है दे दिया था उसमें फॉर.
I think Wahab sir is having an
He
independent.
forgot his mic is not muted.
Yes. Okay. Then furnishing of information, clarification and personal representation by applicant. So if IRDA wants to get some information, clarification, or if they call the surveyor before the license is supposed to be issued, they will have to be appearing before them. Then IRDA will consider all the information that is given and then sees that the person meets all the requirements of 64 UM 42D and eligibility in regulation. Then he will see if he has been refused license earlier, whether 1 year period has expired after the refusal order has been given, which is the cooling period that is supposed to be there. Then whether he is not suffering from any disqualification under 42D, then he possesses qualifications, has passed the exams and completed practical training. On all these being completed, then they will issue the license. So this is the provision where an application has to be submitted within 5 years of enrollment after meeting the requirement. And those enrolled as trainees with IRDA within 1 year from notification or 5 years from enrollment. So this is the interim provision that is there for people who have not completed the requirements, but were in the pipeline when these new regulations came into being or the new act came into being. So that 5 years period at the most. So 2014 was the act. So by 2019, every requirement should have been met. And as of now, everyone who is doing surveyor and loss assessor business is supposed to meet the requirements of 64 UM as well as the requirements that are there in the surveyors and loss assessors regulations issued by IRDA. So once all this is done, IRDA will grant a license. And the physical copy will be given only on request. And these contents that are there in this license is your membership number, then what is the class, department and subject of general insurance business where you have been licensed. So if you are going to take a different subject, then you will have to go through the entire process as if you are applying for a surveyor's license insofar as that subject is concerned. Then validity of license is 3 years. Then cooling period of the license is cancelled 1 year period, and anyone who applies will be treated as a fresh license application and only then processed. In case of corporate, most of the requirements that are there are as if the persons who are there in the firm, that is partners of the firm, or the directors who are supposed to be doing the insurance survey business, they will have to fulfill the qualifications, training, examination requirement, etc. Then they will have to give an application form. Then IRDA has to satisfy again that the requirements are there and the partners or directors do not suffer from disqualifications. Then the other thing is at least 2 directors or partners who are members of ISLA at any point of time should be there. Otherwise, it will be as good as an individual surveyor who is operating through a corporate cloak or a corporate semi-corporate entity if it is an LLP or if it is a partnership. Otherwise, it will be a corporate entity for all practical purposes if it is an LLP or a company. So that is why you need at least 2 people. Then department of license for individual surveyor shall be the department of the company or firm licensed. So this is something which is very important, but most of the times it so happens that big companies which are doing surveyor and license business will have people from different disciplines. So they will, and this is one area which is examined very closely whenever IRDA conducts any inspection. It will see whether the person who has been entrusted at survey work in respect of a particular claim has the competence and is qualified and has been given a license under that discipline. If it is not, then they will charge penalty for not complying with that particular requirement. Then the documents again have to be submitted online and copies retained till the time that they are holding the license. Same in the case with individuals as well. Here also the application duly filled, evidence of fee payment, then membership certificate from ISLA, undertaking by 2 licensed directors, then fit and proper statement and any other document required. What are the disclosures? If there are individuals who are getting into the company or the firm, they will have to indicate that they would complete all pending jobs before joining the company. So they should not be doing their own business being in the corporate surveyor's office. Then they will also have to declare that henceforth they will work only for under the corporate surveyors and loss assessors umbrella. Then they also have to give a declaration saying that in case of resignation, death, suspension of director or partner, or any change in shareholding or other material changes, they will inform IRDA within 15 days. And this is also an area where the inspections have come out with negative reports against the surveyor and loss assessors corporate. they will have to submit this and then seek a modified license after surrendering the original license. Then submit the details of surveyors and loss assessors employed. If they have branches across the place, they will have to indicate where these people are located. Okay. The way, whether they are in the registered office, whether they are in the branch office, etc. Then any other additional requirements are specified by IRDA. Then fees, non-refundable processing fees. This is according to regulation 5. Then application confirming with all requirements will be accepted. Then if they are not confirming with the requirements, IRDA will give them time for completion or rectification. Then any clarification or further information is called for, or if the IRDA wants to personally have them to represent, they may call and you will have to appear before them. Then IRDA, considering the application, IRDA to take all matters into consideration, that is duties, responsibilities and functions, then satisfied that the surveyor and loss assessor is a fit and proper person for license. Then if they meet the other requirements, they will grant a license, and this license will be in relation to particular departments of the persons. Then the license will be valid for 3 years, and they will stipulate conditions. Then survey should be done only in those departments as displayed against the respective director or partner, and if the director or partner should not be a director or partner of any other corporate SLA. So he should do business from one place only, and it should do business in relation to that corporate surveyor only. He should not have individual job being handled, which is the next provision. So individual surveyor to handle job of corporate SLA and in the department allotted only. Then undertake reasonable number of jobs commensurate with resources. So in the order that I have just now, which has been loaded this month, you will find that there are 700 jobs that are done, and one of the person in that firm or corporate SLA did about 690 jobs, and he was available. He was traveling across where physically it was impossible for him to do. That is the kind of observation that is there in the inspection report. So those kind of things will also be examined. Then maintain records in electronic form in format specified. So they have to maintain claim wise, surveyor and loss assessor wise, and these should be maintained in an electronic form, and they should be allowed access to IRDA so that they will be in a position to take the information. They don't have to, IRDA should not be asked to wait for getting this information. It should be available in electronic form and shared with them as and when they ask. So regulation 5 talks about the fee structure. For an individual surveyor, it is 1,000, and for a corporate surveyor, it is 5,000 rupees. Then regulation 6 talks about application for renewal. So 3 years is the validity. 30 days before the expiry of the license, an online renewal application has to be filed with all the documents to IRDA. Then along with this, a non-refundable renewal fee, which is again the same amount that is there for license, that has to be paid and receipt enclosed. Then if you're not applied within 30 days, but before the expiry of, so in that 1 month period between the expiry and 30 days, if you are applying, then you should pay an additional fee of 100 rupees. Then application can be accepted after expiry, but within 6 months period. If IRDA is satisfied that undue hardship would be caused if refused, then they can impose a penalty on 750 and take the application. But if they are going to be submitting their license application, renewal application after 6 months, then the renewal application is not received, and because it has not been renewed, the license will cease to exist. And after 6 months, you should again, that is, if you are coming after 6 months, your application will be not treated as a renewal application, but as a fresh application. Then IRDA may renew license on satisfaction of compliance with all the requirements specified. So the requirements that are there for grant of license and renewal are similar. Then documents to be submitted by individual and corporate surveyors are basically the application, evidence of fee payment, then fit and proper statement, then any other document. Then IRDA will renew the license depending upon the formats that are there in Schedule 2 that particular format will be given, whether it is an individual or a corporate. Then this renewal is also valid for 3 years till it is cancelled, suspended or surrendered. So now these are as far as application for renewal and application for grant of license. Now rejection of an application, on what grounds it can be rejected? First, not conforming with the requirements and failure to comply with Act and regulations. Then they can be rejected. Then if the authority feels that grant of license is not in the interest of policyholders, then also they can reject. But in these cases, they will have to give an opportunity of being heard before rejection. And the rejection has to be communicated in writing along with reasons for rejection within 30 days of rejection. And once it becomes an order issued by IRDA, and according to section 105C, if I am not wrong, there is a provision where any order issued by IRDA can be appealed against by an aggrieved person, and that appeal has to be with the Securities Appellate Tribunal, and it has to be within 45 days of receipt of the order of rejection. So this is as far as the rejection is concerned. Then refusal, it could be on the grounds saying that he has made any false statement about material particulars of eligibility. In that case, you can refuse. Then applicant suffers from disqualification, then also you can refuse. Then in the time that he has been in business, he has not carried any duties or responsibilities as indicated in regulation 13. Then also you can say that aapko license deke koi fayda nahi, so I will not renew your license. But in these cases, they can give them a reasonable opportunity before refusal, and the refusal of renewal will be effective from the date that the refusal is communicated. Then once the refusal is communicated, no surveyor and loss assessor can carry out any survey and loss assessment work, including those that are there on their hand. So immediately they will have to return all the pending jobs to either the insurer or the insured. If he has entrusted the job, then return it to insured. If insurer is interested, return it to the insurer. Then here also the order of refusal, if he is aggrieved, then he can file an appeal with the SAT within 45 days. In case there is a refusal, again there will be a cooling period within which you can't approach for a license. That cooling period is 1 year from the date of refusal. In case the license is torn, mutilated, lost, etc., by application along with the fee prescribed, they will have to ask for. And if it is in pieces, those pieces also have to be sent to IRDA. Then IRDA, on being satisfied, will issue a duplicate license. So this may not be relevant now, because unless you want a physical license, what is available now is an online electronic license that is there. So suppose you wanted a physical license and you took it, and then there is some problem with it, then now you want to have a duplicate license, this regulation 9 will be applicable. Otherwise it's now a redundant kind of a provision. Then but in this particular thing, the validity will remain the same as in the original license that is there. And on this duplicate license, there will be an endorsement to indicate that it is a duplicate that he is getting. Then regulation 10 talks about constitution of the Surveyor and Loss Assessment Committee. So basically, the purpose of this is to assist IRDA. And what is the composition of it? There are 2 representatives. There is an officer of IRDA who is the presiding officer. There are 2 representatives of Surveyors and Loss Assessors. Then there is 1 representative of a PSU insurer, 1 representative of a private insurer, and 1 from a policy holders. And this committee constituted will have a tenure of 3 years. And what will they do? They will recommend the syllabus for examination and practical training for surveyors. Then they will recommend recognition of foreign qualifications and training for grant of surveyor's license. Then they will come out with mechanisms for improving and developing the status and standard of the profession. Then they will coordinate with educational and other institutions who have objectives similar. Basically, their profession here is risk management and risk assessment. So similar objectives, if there are other institutions, they will take them also on board, coordinate with them so that common objectives are achieved. Then they will also look into matters of professional misconduct, indiscipline, and non-adherence to code of conduct by surveyor and loss assessor. Whether this committee will be the disciplinary committee or not, That's not coming out very clearly, because ultimately the decision insofar as these have to be taken, one by the insurer and communicated to IRDA, second by IRDA itself by appointing a designated person. So what will be they observing is the general trend of misconduct or indiscipline or non-adherence to code that is there, and suggest mechanisms for improvement therein. Then discharge any other function that is entrusted to them by IRDA. So they will meet as frequently as necessary to conduct the affairs. Then IRDA officer, who is the chairperson of that also, he will decide the venue, time and frequency of meeting. Then non-IRDA committee members, for participating in the meeting, coming, etc., they will be eligible for allowances as determined by IRDA. Then appointment. So this is the operational provision relating to section 64 which says that the amounts will be decided by IRDA, and that is what is contained in this regulation 12. So no person, firm or company shall act as surveyor and loss assessor without license under regulation 3(4). Then surveyor and loss assessor shall be appointed by insurer or insured to assess loss under policy, where it is a motor policy above 50,000 rupees, and for motor other than motor insurance 1 lakh. And this limit will be reviewed by IRDA every 3 years. So this limit was brought about in 2015, and I think we are in 2021. So 6 years have passed and the limits continue to be what they are. Then the surveyor and loss assessor appointment within 72 hours from time of knowledge of occurrence of loss. So this provision is something which is also there in the this provision is there in the policyholder protection regulation. Then a notice in writing of appointment is to be given to the opposite party, and this should be a part of the claim settlement process. So basically, insured or insurer can appoint, and the other party should be made aware that there is a person who is appointed as surveyor. Then surveyor and loss assessor should assess losses of only those departments that are specified in the license. So the one in fire cannot do agricultural loss assessment. Then what are the duties and responsibilities? So there is a big list of things that the surveyors and loss assessors are supposed to be doing. In fact, the duties and responsibilities section talks about the sequencing of what is supposed to be done also, though it is not in the right kind of sequence that it should be there. So what is the duty? Basically to investigate, manage, quantify, validate and deal with losses, whether insured or not, arising from any contingency, and report thereon to the insurer or insured as the case may be. So basically to do the investigation and also quantifying it and then informing in the form of a report. Then the second duty is this work that they are supposed to be doing in one, they should be doing with competence, objectivity, professional integrity, and strictly in accordance with the code of conduct that is stipulated. So what are the duties here? First, whether he is an unbiased person or not is first something that he should come out with. So if he has any interest in the subject matter or the persons who are involved, he should make a clean breast of it initially. Then notifying IRDA of any change in information and particulars having a bearing within 15 days. So this is something which he gives a declaration, and to comply with that declaration is the second aspect that is there for him. Then maintaining confidentiality and neutrality without jeopardizing the interests of the insurer or the insured. Then conducting inspection or re-inspection of property in question suffering loss. So the moment he gets a notice, he goes and has to conduct an inspection of the property in question. Then examining, inquiring, investigating, verifying and checking upon the causes and circumstances of loss. So whether it is fortuitous or whether it is man-made. Then the extent of loss, the nature of ownership and insurable interest, whether the person has insurable interest or not. All this have to be investigated, inquired upon and made a part of the report. Then conducting spot and final surveys and commenting on franchise, excess and under insurance or related matters. So now he is done with that. So now he is talking about whatever contributions have to be made by the person or whatever less insurance he has taken for adjustment of that claim, that has to be examined and indicated next. Then estimating, measuring and determining the quantum and description of the subject under loss. So here is the quantification of the loss. Then advise insurer and insured about appropriate loss minimization, loss control, security and safety measures to avoid further losses. So here he will have to, because he is going 72 hours, within 72 hours, if there is any mechanism of salvaging and minimizing the loss, he must do it forthwith, because he is supposed to be an expert in risk assessment and risk management. So this duty is a very important duty that needs to be performed. Then commenting on claim admissibility and assessing liability as per the policy. This is understood. Then surveying and assessing loss on behalf of insured and insurer. So this should have come first. Then satisfying queries of insurer or insured or other persons regarding claim or loss. Then recommending applicability of depreciation, percentage and quantum. Then giving reasons for repudiation of claim if not covered by policy terms. So he will not give a reason for, he will give reasons to the insurer, who will in turn confirm whether those reasons are applicable, so that he will use those reasons for repudiation of the claim. So then if he feels like, he can also take expert opinion wherever it is required. Then he can also comment on the salvage and its disposal wherever it is necessary. Then any surveyor or loss assessor appointed as director, partner of corporate surveyor shall undertake work only as director or partner. So this is the third time probably that they are saying the same thing. So this is as far as the duties and responsibilities are concerned. Then those provisions that are there relating to the timelines, which are there in the policyholder protection regulations, they have again been reproduced here for abundant caution probably. Then a surveyor or loss assessor shall submit a report to insurer as expeditiously but not later than 30 days of his appointment. Then give a copy of the report to insured with his comments or on insured's consent or otherwise on loss assessment. So these two things are very important, and several penalties that are imposed on the surveyors and loss assessors are because of the delay that is there. And there is a provision within the regulations for delay also, where in special circumstances of the case or because of the special and complicated nature, there is a need for extension. The surveyor or loss assessor can seek an extension, but he has to keep the insured intimated about it. And the time period that should be taken should not be more than 6 months for submission of report. And where it is pending for submission of documents by the insured, he will have to give reminders within, and minimum 3 reminders in writing should be given to the insured and documented, so that tomorrow when IRDA people come and say that you have not kept him informed, then they should show this reminder saying that usne ye nahi diya, I am having it on my record. Then final report, they will have to, if in spite of that they are not giving, then they can go ahead and make a final survey report based on the available records. Then finally, if the insurer finds the surveyor report incomplete, then he can say that you bring me an additional report on incomplete issues. But this can be brought in only once. And this request also should be made within 15 days of receipt of the survey report. So once this additional report is called for, this has to be submitted within 3 weeks of the date of communication. So ideally speaking, the job should be done and dusted in about 6 months plus another 5 to 6 weeks, which is about 7 to 8 months. The job should be over. But are these jobs getting over? And there are some people who say that reinstatement will take some time. So automatically you will not have that happening within that period. So that is where probably admitting liability and saying that I will be complying with it and ensuring reinstatement should be treated as compliance as far as the claim settlement is concerned. Then functions of ISLA is an important aspect. So they are granting of membership to eligible persons. They have to do it within 15 days, but this doesn't seem to be happening. The other important function is in relation to capacity building, that is conducting training, seminars and workshops. And these should be done with the prior approval of IRDA. And the post-license training can be given by the institute. It could be direct or it could be online. And this is a part of the continuous professional development. But this upgradation of knowledge is not a prerequisite for licensing or renewal. This is a provision that has been made basically to deal with IRDA and ISLA feud. If ISLA declines student membership or membership, the person can appeal to IRDA. Then IRDA shall consider the application and communicate its decision to the person and ISLA within 6 weeks of its receipt. And the decision is binding on the person as well as ISLA. And if ISLA does not comply with IRDA decision, then IRDA may issue license to applicant on merits without ISLA's membership, and the decision is binding on ISLA. IRDA may issue guidelines, directions, or communication for efficient conduct of affairs by ISLA. So basically, here IRDA is imposing itself and creating a provision where the person who wants to become a surveyor and loss assessor does not suffer because of the incompatibility or issues between ISLA and IRDA. Then the code of conduct, chapter 6, it talks very elaborately about 23-24 tenets are there. Then trainee applicants is section regulation 17. So a student member seeking license shall enroll with IRDA to pass exam and undergo practical training as specified. So what are the do's and don'ts for this member? He should behave ethically and with integrity. And integrity is not honesty. That is a very nice thing that they have written, that integrity doesn't mean honesty. It means fair dealing and truthfulness. So that is what is intended to be the role of a student member. Then not to undertake survey and give report without license. So it's as good as a house surgeoncy, whoever is conducting an operation, that is not permitted. Then maintaining proper record of training. Then disclosing information regarding proceedings initiated against him, investigation pending, or those which are carried out by any agency, and details of the outcome, because this will have an impact on his eligibility, or it could lead to a disqualification. Then they should follow other instructions that are given by IRDA from time to time. Then they should pass the exam and also submit the training completion certificate. And for additional departments, they need to fulfill the eligibility criteria. Then once they are fulfilling those requirements, that student membership will come to apply as for a license under regulation 3. Then a register of licensed surveyors and loss assessors is supposed to be maintained by ISLA, and various particulars have to be incorporated in it. Then periodically this list should be deleted or cancelled for those who don't have the license or who are now no more in this world. So they should make this list a proper list, and IRDA may get this list to be published at such intervals. I think in about 3 to 4 months time, they will keep publishing this list on IRDA's website. Then now the next sections are talking about reports. One report is from the surveyor and loss assessor. There is one report and documentation as far as the insurer is concerned. Then that register which is there of ISLA. So these are basically the mechanisms of information and reporting that are there. Then surveyor should furnish every document, statement, account, return or report as and when required by IRDA and comply with the directions issued by IRDA. They should submit an annual statement in form in schedule 2. Basically what is the business, etc. All that has to be furnished in that statement. In case of a corporate SLA, surveyor and loss assessor, they should give an annual statement and they should give a copy of the audit report, and they should submit both these by 30th September every year. That is within 6 months of the close of the year. Then a surveyor submission of returns by insurer, basically this is a mistake that is there in the slide. Every insurer should basically have a board approved surveyor management policy, a mechanism of empanelment, and how they are going to utilize these and how they are going to allot the survey jobs to those who are empaneled. That is what is supposed to be there in this surveyor management policy. In addition to it, whoever surveyors they are employing for the jobs, they will have to monitor their compliance performance. They will have to examine their compliance with code of conduct and the duties and responsibilities. Then in case there is any observation relating to violation of code, they will have to take them. They could be getting complaints also. They will have to examine, inquire and investigate into them, and then report those cases of established violation to IRDA immediately. Then they will have to file a report on misconduct of licensed surveyor and loss assessors annually with IRDA. then they will have to maintain details and records in electronic digital form, and for ease to submission to IRDA. And this is a very detailed kind of a report that they will have to maintain. So the report should have information about utilization of surveyors depending upon lines of business, estimated claim amount, etc. Then the timeliness of submission of reports by surveyors and loss assessors should be captured in this report, in this record. Then complaints against them and how they have been disposed of, and if any action has been taken, what is that? That has to be documented and made available. Then where the survey fees have been paid or pending, that has to be recorded. Then what is the mechanism of monitoring of performance? Whether there is a quality of conduct of survey, timeliness, compliance with code of conduct, all that also should be recorded. Then quarterly data of misconduct, etc. and action taken has to be submitted. Then half yearly data of information relating to surveyors and loss assessors function, that is also supposed to be submitted to IRDA. Then the total number of claims reported, etc. So this data has to be maintained in a very granular manner so that IRDA can take up the next, that is inspection. So for this, IRDA may appoint one or more persons as inspecting authority. What do they do? Inspect the survey work done, books, records and documents. Then they will investigate any bona fide complaint received against the surveyor and loss assessor. And based on that, the inspection authority will submit a report to IRDA. Then the surveyor and loss assessor is supposed to provide information and extend all cooperation. So based on the report, IRDA will communicate the findings, and where action is supposed to be taken, there will be a reasonable opportunity of being heard. They will have a personal hearing also, and then they will inform the order. And as usual, this order can be challenged before SAT. Then the next aspects are, I will finish this and then come to any discussions, etc. because there are only one or two items that are left which are substantial. One is suspension of license, then cancellation and voluntary surrender. So it will all be simple. Then IRDA may suspend the license if they fail to discharge duties satisfactorily in a professional manner. They violate code of conduct. Then they are making false statement regarding their eligibility for license or renewal, then also they can suspend. Then they acquire disqualifications. Then they contravene any provisions, or they are found to be negligent in discharge of their obligations. Or if they are sentenced for a term of imprisonment for whatever reason, they will be, their license will be suspended, and they will be given an opportunity of being heard. But the opportunity for suspension, I find that it may not be necessary. But IRDA, in these cases, IRDA will give them an opportunity of being heard before they suspend. But where the continuance of license would be prejudicial to policyholders' interest, they may suspend the license without giving them the opportunity of being heard also. Then IRDA may not only suspend the partner or director, but also the corporate license. So in a corporate entity, they do it for the whole entity, or they may do it for individual partner or director. Then the suspension order will indicate whether it is for a time or whether it will be enforced till it is revoked. Then during suspension, the surveyor and loss assessor is supposed to not handle any work, and whatever pending job is supposed to be returned. Then cancellation of license, basically whoever suffers from disqualification or who has contravened the provisions, IRDA will cancel the license after giving reasonable opportunity. But where his continuance with license is prejudicial, they may cancel without even an opportunity of being heard. And 1 year cooling period is given for him to make a fresh license after cancellation. Then the license surveyor and loss assessor, where he is given an opportunity of being heard. So the order of suspension will be given, and the surveyor and loss assessor will make a representation to IRDA for its revocation or for not cancelling, and that representation is supposed to be made within 45 days of the order. If it is not made within that period, then the license may be cancelled by IRDA. Then IRDA, if there is a representation that is made, then IRDA will designate an officer to consider the representation, and this officer will pass an order, and that will be communicated to the suspended surveyor and loss assessor. So based on the order, IRDA will decide either to revoke the suspension or and restore the license or cancel the license. If they are restoring, then the date of restoration will be indicated, after which they can continue the business as if the license will be continuing. Then any decision of suspension will revocation or cancellation will be intimated to the surveyor and loss assessor. If I am not interested in doing business, I can simply surrender my license and then say that I will opt out. So here the declaration has to be given indicating that he has completed all assignments and he is not going to take up any fresh cases after the date. Then in case of corporate surveyor, because their memorandum and articles of association or the partnership agreement will have a clause saying that this will be their main business, they will have to, and they are operating based on the board resolution, they will have to have a board resolution indicating that now they are no more interested in dealing with the corporate survey and loss assessor license. So they will have to give that. Then they will have to take up for modification of the memorandum and articles, taking that away from their main objects. Then the original copy of valid license and any other information has to be given. So if IRDA accepts, they will pass an order of accepting the surrender. Then from that day onwards, they are not supposed to do any work. Then as usual, power to clarify with chairman. Then qualifications are, the requirements of qualifications are prospective and applicable to those who apply after the notification of these regulations. So any new department, they will have to fulfill the eligibility requirements relating to those. So this is as far as the entire story as far as the surveyors and loss assessors regulations are concerned. So let me just show you the summary of the orders that have been issued by IRDA, because that will give you an indication about what are the aspects that they have seen and what they have ordered. So this is a summary of decisions. So the charge that is there is they have not maintained records, and the provision that is violated is indicated. Then the decision that they have taken based on the representation is to give them a caution and direct that they should meticulously comply with the requirement. The second thing is, the charge is that survey has been conducted by persons other than licensed person. So in this case, there were 2 cases where they found that this problem was there. So for each case, they have imposed a penalty of 1 lakh and said that the total penalty of 2 lakhs is supposed to be paid. And they have been cautioned and given a direction to comply with that meticulously. The third thing is non-submission of requisite information that is there in the provisions. Again, they have given a caution. Then not seeking extension from insurer. This is important while they are not submitting the report on time, and then they have to approach the insurer. If they can't give it within 30 days, they have to approach the insurer, intimate the insured that they need time, and then get reminders. So there they have given a caution saying that, and advisory saying that you have to comply with those requirements and keep documents of that also. Then intimation regarding appointment of directors. So this is also very important because any change that is material has to be intimated to IRDA within 15 days. So they have not done that. So again, they have given a caution and advisory. So this is one order. The other order, there are only two items that are there. And there also one delay in submission of survey report. So they have referred to section 13 and also the policyholder protection regulations. And here they have left them with a caution. Then again, unlicensed individuals doing survey job. This is an item which is seriously considered and penalty of 2 lakhs was imposed, because here also they found two days where that happened. So this is how the order looks like. So when the inspection has been done, then they will say who are the persons who are there. Then a personal hearing was given. Then there will be an individual charge. There will be observations made by the inspection team. What is the reply that is given? Then what is the decision of the authority, and then the consolidated decision, and finally they will say that this amount that is supposed to be paid has to be paid to this particular authority. Then compliance has to be done within 21 days, but you have an appeal provision under not 105C as I told, but section 110. 105C is, I think, an adjudication procedure cases are there in 105C. So here section 110, they can file an appeal with SAT. So this is as far as the instances of orders that have been issued against the surveyors and loss assessors. So my breathless is over now. Now you can, if you have any questions, you can ask me. Yes, sir. Hope I am on network.
Sir, I am Ganeshan.
Yes, sir.
My question was, individual SLA as well as corporate SLA.
Yes, sir.
Because my colleague has rightly said that only corporate SLA registered officers are there in and around in our country, so that they can depute the surveyor to the corporate SLA. As far as individual SLA, sir, we have come across one claim for communication network synthetic fiber claim of 10 crores. Whereas the insured had not allowed us to inspect that synthetic fiber that related to communication networks because they don't want to share the business secrecy. Finally, we have taken with the matter corporate SLA as well as individual SLA. Very individual persons who are expertise only, they can able to comment upon that synthetic network, the fiber for the communication networks. Then salvage normally was there. Then we have indirectly searched the competitor. The competitor he has intended to take 8 crores that the salvage value. Finally, we have got individual opinion from the expertise person. Then finally we have settled only 2 crores from to the insured.
Okay.
Similarly, the individual SLA is also authorized to register the names in the IRDA, sir, for having done in professional job.
See, basically, the IRDA what is required is a address from where they are operating. In case of a registered entity like a company, there will be something called a registered office from where they are operating. In other cases like me and you, we will have only our places of residence. So, so in case of an LLP or in case of a partnership or in case of a company, the place of registered office of it is something which is a very important requirement that is supposed to be met. In case of an individual, it is only required from the survey, from the KYC perspective and also for communication address perspective. That's all. But that
irrespective of the experience, irrespective of the citizens, they can be anywhere in the world. Individual SLA.
Yes. No problem. If there is someone who is an expert, you will bring from there. Like what you have, Harish Salve will be called for a case of Arnab Goswami because he is an expert. For Mallikarjun, Arnab, Harish Salve will not come. And if I am able to pay, Harish Salve will come also. So like that, it's basically the expertise and the ability to get him to the competence. In case of survey jobs, it's basically the competence that is should be taken into account while you are picking a particular surveyor, not the fact that he is a corporate surveyor or an individual. Ideally, all said and done, corporate is only for a corporate structure, but ideally the persons who are operating in the corporate insurance and surveyor are the ones who are there. It's a different corporate entity than what is there for a company. Here it is the competence of the persons which makes the corporate surveyor, not that the not other way around. So that's the
limit of liability is also restricted.
Which one, sir? Correct.
Private company, private company or public limited company.
What
company or yes, sir.
What is the kind of liability that will be there? It will be only a professional kind of a liability that will be there. So that you can that and what will be the contribution that people will be having? Maybe you will have an office. Maybe you will have a few vehicles. So it will not be. I personally am not. I don't know if people here who are in the surveyors are belonging to a corporate surveyor company, they should be indicating how their company is a very important. That corporate structure is very important for them. Otherwise, I personally feel that a conglomerate of people who have competence in different things, whether they are like an LLP, if you can have an LLP of up to 50%, I suppose, or 20%. So if you have that many people, that is more than enough. Every discipline के बंदे को लगाओ, and क्या liability होगा उसमें?
Because the IRDA imposes some penalty because the corporate SLA, they are joint and severally liable, sir.
Corporate, see, if a company, the liability part of it will be operating in accordance with the law under which they are constituted. I am not about that. So if you are a company, then your liability is limited. If there is a distinct corporate legal entity as far as anything is concerned. But here, because it is the person who will be handling that job, and there is a bad faith related kind of a complaint that could be there against that person, it will only be the person who will be liable. There will always be an occasion for the corporate to be taken off. Only non-survey business related liabilities will be something where the company corporate structure will help. Otherwise, the only liability in relation to your work will be in relation to the individual's liability only.
So the corporate
basically
SLA
it is
or the penalty. Corporate
any
SLA,
other question from any other members?
Okay. Yes, sir. Please.
Sir, someone was responding, sir. I think Sudhakaran sir.
Basic. Myself, Jamin Shah here. Basically, the difference between individual and corporate surveyor is individual, a single person will be handling, and corporate surveyor, 2 or 3 or 4 surveyors coming together, forming a company and running. Basically, as Mallikarjun sir rightly said, it's the individual who is handling the case in a corporate firm. He will be ultimately responsible for everything at the end. The person who is visiting the site, inspecting the damage, assessing the loss, all that. So corporate entity, the difference is only that 2-3 surveyors are coming together and working in a corporate structure. That's all.
Correct. In fact, the reason why LLP Act came into being is only for this, that professional body, like your advocates, chartered accountants, then your surveyors and loss assessors. So these kind of people, instead of having a partnership and coming together, you could have an LLP structure which will provide you a better corporate structure, a registration. Then, so that structure is more than enough. I personally don't feel that a company is necessary for a surveyor and loss assessor business.